educational standards here at the State Bar, and I'm very happy to host a joint meeting of the Law School Council and the CS Bars to give an update on several important bar initiatives that are going on right now. I will turn the meeting over to our two chairs, who are Dean Susan Prager and Dean Jackie Gardina, who will welcome you, take roll, and approve the minutes from the last Law School Council meeting.
Welcome, everyone, and I want to extend a special welcome back to the CS Bars members who all were in a meeting for 5 hours last week. So I appreciate your continued attention and attendance.
This is Susan Prager from the ABA body. I'd like to note that a number of our members are on the phone and some present here. I wanted to say at the outset that this joint meeting will concentrate on, in particular, one set of substantive issues that have to do with the study relating to the appropriateness of content on the bar exam, and it's been structured to include significant substantive discussion, questions, and comments from this body. I'm sure that each of the two bodies have other business that they want to engage in, will be engaging in, but the purpose of this meeting is time sensitive, and so we'll be concentrating on that issue and hopefully have time for a couple of other brief updates on other projects underway.
Michael, would you mind taking roll?
Not at all. So for the Law School Council, Susan Prager is here. Let's see. Susan Bakshian.
Here.
Michael Colatrella. Jennifer Manukin. Anthony Needwicki.
Here.
Donald Scotton. Don Smythe.
Here.
And for CS Bars, Greg Brandes.
Here.
Jackie Gardina.
Here.
Kareem Gongora. Jay Frickberg.
Present.
Martin Pritikin.
Here.
Brian Pertil.
Here.
That's all.
So we have approval of minutes of previous Law School Council meetings. Any comments, additions? If not, the Law School Council members are the voting members. Those in favor?
Aye.
Approval? You need a roll call? Okay. So we have Anthony and Susan here. We need a vote.
As to
Approval of the April minutes. Anthony was not a member at that time, so he probably cannot really comment. Susan?
Do we need to move it
Yes.
for approval?
Yeah.
I'll move it for approval.
And then you have to, what I'm hearing is we need a roll call vote on these because we have people on the phone. So
I vote to approve.
and I vote to approve. On the phone, Dawn?
Yes, I approve.
I think that's it.
And abstain.
Okay. So, do you have any minutes? Okay.
So at this point, I'd like to invite Director Amy Nunez to provide State Bar updates.
Good morning. I'd like to update everyone on the admissions information management system. As you are all aware, back in March, we went live with our new information management system, This is a system that allows students to register for as law students and for the multiple exams offered through the Office of Admissions. Since that time in March, we've experienced glitches with the system. They include problems related to data migration and some with automation. We've also now used the system for 2 separate exams. So for the last 2 bar exams, February 2019 as well as July, and for the June first year exam. In that process, we've learned about new needs that are required in the system. And so, and these are considered enhancements that were not in our original scope of work. And we're addressing this in our next phase of fixing and addressing some of these technical issues. The deans were impacted when some of our allocation and certification lists were inaccurate. And so we are, and we did to address that is staff used manual processes to correct these errors and to send out corrected versions of these documents. We're now seeking to resolve these issues by contracting with our vendor to address these issues. So it's the glitches that we've had as well as items that we'd like to include as part of our enhancements. So all this to say that we're asking for your patience, that we are trying to ensure that we get you the most accurate lists. If you have any questions or concerns that perhaps you or your students experience, please don't hesitate to send those to us. We are working in the meanwhile in the Office of Admissions to address these issues, and we definitely have a plan in place to do that. So any questions related to the AIMS system? Okay.
Just a quick question. Do you expect to have the certification issues again in February?
No, we don't. As I mentioned, we have a manual process in place right now. We're hoping to have the system ensure the automation. So we are reviewing each of those lists for accuracy at the moment.
I have a question.
Yes.
Can you elaborate on what data migration problem there was?
Yes. So we've been using the AS400 for I'd say over 20 years. This is a previous information management system that we had. We needed to move some of that data that exists, so student records, into our new system in order to have a history. So for example, students who have taken the first year exam or bar exam previous years, that data needed to be migrated over into the new system. We also needed to merge that data with any new information. So for example, somebody who took a bar exam in 2016 and now wants to register again, we would need that data to come together. We had issues when some of that data didn't migrate accurately or some didn't migrate altogether. And we've had to compensate for that by either manually engaging and correcting some of that. And it differs from in various fields. So that's the manual process that I'm referring to. Our automation didn't work because we had data migration issues. And it didn't happen overall. There was certain fields and definitely the eligibility areas, and that is eligibility to sit for the bar exam was impacted. And that's how the lists were impacted.
So it was an issue of data migrating from one of our older systems to the current one, not from the current one out into the blogosphere or something?
No, it was from the old system into the new system.
Thank you.
All right. Thank you.
Are there some other recent developments that need to be covered at this time? Or
just one quick one. Just one quick development, just a reminder that all of the deans for all of the California law schools should at this point be receiving the State Bar's e-newsletter that was sent out in May, again in August, and will be coming up in November. That quarterly schedule was created to, as often as possible, coincide with the release of bar exam results, and you can always submit submission topic ideas to the State Bar as well.
And so now we'll turn to the discussion of the preliminary results of the California Attorney Practice Analysis. Amy?
I'd like to welcome at this time Ron B. from the State Bar's Office of Research and Institutional Accountability to give an update on the California Attorney Practice Analysis.
morning, everyone. My name is Ron B. Most of you, if not all of you, must have heard some parts of the process or preliminary results. This study was funded by Accredited. We got the grant last year, and the first meeting of the working group took place late last year. And since then, we have had many meetings, and all for the purpose of just reaching the point of sending out the survey, which occurred in August. So today I'm going to share with you some of the results, and we're still doing a lot of analysis. We've got tons of data involving 2 different surveys, very different methodology. So initially, I'll just go through the project timeline, where we started and where we are now, and the purpose of the study. Purpose of the study is linked to the previous series of our exam studies, standard setting, content alignment, and this is really just getting into the issue of what new attorneys need in order to be practice ready in terms of legal knowledge and skills, and as a way of measuring it in terms of the depth and breadth of each of the domains. And use the results of the survey to develop a new attorney minimum competence definition, which would feed into the design of the different aspects of the bar exam. Starting from late last year, we went through 2 major phases, as shown on the diagram here. The first phase is really just to discuss the framework of the survey. I remember the first meeting, the 2 major framework in this kind of job analysis, you can look at the performance aspect, which is largely oriented toward doing the daily task as a way of testing the knowledge and skills of the licensees. Another framework is to look at the knowledge domain. And we, based on a lot of discussion from the working group members, we decided that we have to cover both of them in sort of a matrix, encompassing both the performative as well as the knowledge dimension of the profession. After that was settled, we had another group, we call it the practice analysis panel, over a 2-day period. Based on that initial framework, the goal of the panel was to develop all of the details to fill into the 2 dimensions. Performance, to have at the end 117 specific tasks that were grouped into 4 major areas of responsibility, and 13 later on we call the competency areas. And as far as knowledge domain is concerned, we started out with the 13 topic areas on the current bar exam, and further expanded it into 19 knowledge domains or legal topics, plus 1 non-legal topic area as the basis for the survey. After getting all of those details, 117 tasks and 144 legal topics and subtopics, we produced a pilot survey instrument. We tested the survey in May and got some results. We modified the survey design a little bit. For example, in the experience sampling survey, instead of giving the respondents option of selecting 1 legal topics, they now have the option of selecting up to 3 legal topics in relation to whatever task that they were performing at the time of getting a notification for the response. So after working through all of those modifications, we distributed survey in early August, traditional survey and the experience sampling survey. We presented earlier results in the last working group member meeting, and we also scheduled 2 additional conference calls to dive further into the data in preparation for the next working group meeting to have a better understanding about the implications of the data on bar exam, different aspects of the bar exam design. So traditional survey responses, out of the 190,000 licensed active attorneys, we divided them into 3 groups because we have two versions of the California survey, the traditional job analysis survey and the ESM survey. The third one, we collaborated with NCBE, who happened just by coincidence to be going through a similar kind of a job analysis study. We shared at 1/3 of the distribution for their survey, all happened in August. So traditional survey out of the 63,000 that were sent out, minus the bounce back results and the actual participation rate, is about 23%. Participation rate meaning the respondents completed some portion of the survey but didn't go through all the way to hit the submit button. For those who completed all of the questions with all of the data that we needed on both the performance, task, and legal topics, we have about 8% response rate from the traditional survey. ESM survey, the structure is very different. There's the first part we call onboarding, getting some basic demographic and practice setting information, followed by daily notifications. For young attorneys, we send out 3 per day for a week. For more experienced attorneys, they received 2 notifications per day, also for 1 week. So the maximum number of possible responses is 10 for experienced and 15 for younger attorneys over a period of 3 weeks. We divide it into 3 weeks, depending on their availability and their preference. Over the 3-week period, the first week, we saw a very consistent response rate, about 60 to 70%. Second week is also okay. The third week, we began to see a little drop. That from the beginning was our concern, because for this kind of a survey methodology, to keep people engaged over a period of time is the biggest challenge. So, but at the end, we received close to 74,000 total responses involving more than 10,000 individual attorneys with an overall response rate of 64%. Some basic profile of the respondents. This is from the ESM survey. Without going into detail in comparison with the traditional survey, I can tell you the results are very comparable because it's randomly distributed based on the 2 samples, and we compare the results in terms of profile. And for the ESM, the years of experience, we knew from the beginning those with less than 3 years accounted for overall less than 10%, and this is what the response pattern also shows, consistent with the traditional survey as well. In terms of practice setting, close to 60%, traditional survey a little higher. I think it's about 63%. But overall, it's very comparable in private sector and the rest of it in the other additional sectors. So these are important background information that when we look at some of the major scales in the survey, we have to control for, and I'll get into that later on. Practice area, starting from civil litigation, that's the highest percentage, 16%. This included others, those who selected the other, about 9%. This is the choice where they can select more than one, so the total N, even though we have about a little over 10,000 respondents, the total number of selections is 17,000. And what I displayed here are only those areas that's selected at accounting for more than 3%, out of a total of more than 30 practice areas that were given as the option. In terms of firm size, about 1/3 are solo, regardless of the practice setting. At the other end of the distribution, 12% of the respondents are in firms or organizations with more than 200 attorneys. And this is also very similar in the traditional survey response. Getting to the actual response data in relation to what we could say about connection with bar exam. The first one is distribution of the task area. Remember, the navigation of the experience sampling survey, the first set of a question we ask is, what are you doing at this point out of those 4 major areas of responsibility, 13 competencies, and 117 specific tasks. What's displayed here is all of those grouped into 13 areas and broken out by years of experience from 1 all the way to
Don Smythe has left the conference.
To more than 10 years of experience. What's striking is as attorneys gain more experience, the most frequent task area, drafting and writing, started to decline. And just focusing on those with, in the first year, 3 task areas account for 60% of their time on a day-to-day basis. The second part of the survey, after they selected the task that they were performing at the time of getting the ping, we asked, what's the legal topic that you use to perform the task? And this is a distribution of up to 3 legal topics that they selected. Up to 3 is the result of the pilot, because a lot of people say, whatever I'm doing, sometimes I just use one specific area, but a lot of times I use more than one. So we gave the choice of selecting, and this is the results of the distribution of all of those selected, including the other, which account for the largest percentage. And also highlighted here is the non-legal ranked 5th overall. You can see here just a few of the legal topics, including other, account for a large percent of their day-to-day time. Not removing the other and the non-legal topics, you can see that 6 topics account for 60% of first-year attorneys.
So for those people who didn't bring their magnifiers, can you read what those 6 areas are?
Yes. Civil procedure ranked the top. Contracts, employment, administrative law and procedure. This one is a surprise to me. Criminal law and procedure, torts. Those are the 6 highest ranked percentages. The other legal topics, we want to know whether we miss anything important in terms of other legal topics. And the structure of the ESM survey, given the opportunity to select outside the 19 legal topics that we provided. And this is an example of going through all of the text, trying to recode them into categories. What we found out is many of these we could easily recategorize them into the existing categories. And in the survey, we actually provided hover over explanations about the specific legal topics, what they might include. For example, in the attorney practice panel, intellectual property came up quite often, and the consensus was that we should be able to cover that under either administrative law and rules or contract and some other more traditional topical areas. But still, we have people selecting other and then put in intellectual property, which account for 12% of the overall others. And also some additional random kind of a comments about the other topics, just as a sample, like spell check they are doing. I don't know why it's legal topics, or sociology of homelessness and math. But this is just give you an indication of the comprehensiveness of the design of the survey to capture everything that they do, the knowledge domains that they use. When we looked at the data, a lot of times we thought it makes sense according to anecdotal information we hear from different sources. But one of the things as a survey instrument we want to make sure is the results are reliable. Reliable in the sense of some statistical measure that's often used to assess the reliability of a test instrument. For example, bar exam, MB portion often have this reliability measure ranging from 0 to 1. 1 is the highest reliability. Bar exam, MB portion has alpha reliability score of 0.9495. The written portion ranges from 0.75 to 0.85. Partly this is affected by the number of question items in a survey instrument. Another thing is the reliability, the actual reliability of all of the related elements in the survey. And we are very pleased to see this instrument actually gave us quite reliable data. And as a test instrument, anything that's over 0.8 is considered very reliable or excellent as an instrument. Now looking at the distribution in this table of the average scores of criticality, criticality being one of the ratings in the survey in both traditional and the ESM survey. Criticality in terms of how important they think the task that they are performing, and if without the proficiency, what's the degree of harm they think their action would cause. So this is a very important measurement on their tasks and knowledge proficiency, and broken out by all of the task areas. You can see from the initial establishing client relationship, maintaining the client relationship in the order it's presented, coming from the attorney practice panel, it represents the chronology of cases going through the entire process, all the way to the end of a litigation and negotiations. And broken the data out by years of experience and color-coded with the red on that spectrum representing higher scores, and red representing lower score, and green higher scores. You can see it trends toward higher scores with greater experience, as well as the end of the process. So for example, the earlier process, establishing relationship, maintaining client, across the board, you tend to have a lower ratings on criticality or potential harm of their actions. As you move through the process of the case, reaching litigation, you begin to see their assessment of the criticality going up. Another measure, this is one that's only available that we used for ESM. After the answer to the question selecting the knowledge domains or legal topics, we asked what's the cognitive complexity of the knowledge that's required in order to perform competently the task at hand. Or using the Bloom's taxonomy, this is a measure of the depth of knowledge on a 5-point scale, one representing the basic ability to just recall factual information, all the way to 5, the highest complexity, involving the ability to do some analysis, evaluation, and synthesizing all of the information. So what's presented here in this table is the average of all of those legal topics that they selected. We don't see as clear a pattern, even though the table here is ranked by the total, starting from the highest. Constitutional law is rated to require and the highest cognitive complexity or depth of knowledge in utilizing that knowledge to perform that day-to-day task, followed by environmental law and land use, employment, evidence, administrative law and procedure, legislation. What's interesting here is, other than those non-legal topics include time management, statistics. That's ranked the lowest in terms of what they need to do their job, is professional responsibility. And this is a total surprise, especially in comparison to the results of the traditional survey, where the criticality of professional responsibility is rated the highest. So we had some discussions in the follow-up focus group, which came from attorneys who completed both the traditional and the ESM survey. As expected, it's the difference in the frame of reference. When they responded to a survey from ESM, it is the frame of reference is more directed to whatever they are doing at hand. So what we got as a result is the average of day-to-day tasks and the relevance of all of these knowledges to what they are doing. For traditional survey, the way the questions were framed is over the past 12 months, what's the criticality? What's the potential harm of all of these tasks and knowledge domains? So that is more like a reflective or evaluative assessment of all of these items. And based on recall, as we know, it adds some of the values judgment, as well as part of the value judgment, you might have some of the what's often referred to as the saliency bias. You just tend to think something that's more salient or more important. But I wouldn't say whichever one is more reliable or accurate representation of the underlying data we're trying to get to. But it's just interesting to have that contrast and have a better understanding about what accounts for the difference. Looking at all of these dimensions, as I mentioned, whether it's the depth of knowledge, whether it's related to task or the knowledge that they perform, there's a lot of connections among all of these as a way of just looking at what accounts for these changes. This chart, in a way, it's multidimensional. On the horizontal axis is the average rating of criticality for all of the task areas. The legend here listing all of the 13 task areas, which is represented by each of these bubbles, and the size of the bubble reflects the frequency of those task areas selected. On the vertical axis is the measure or their response on depth of knowledge required to perform those. And what's currently showing is the response results from year one attorneys. We want to see, as they gain more experience, how all of these ratings change for all of these. The thin lines here represents the movements of each of these bubbles through different years of experience. Without paying attention to the movements of the individual bubbles, the overall trend you can see here, it's trending toward upper right corner, which means as attorneys gain more experience, they rate all of these higher on both dimensions in terms of criticality and the depth of knowledge. Starting from year 1, 2, you can see the movement of all of those bubbles, especially the larger ones. It's very consistent. Back to 1. Here's a similar chart. Instead of a tasks, it's a rating of the knowledge domains on the same 2 dimensions, criticality and the depth of knowledge. It's not as tightly, according to all of these lines, clustered in the movement, but still showing some overall trend moving toward the greater criticality and depth of knowledge, especially for those larger bubbles. Year 1, 2, you can play on these charts for quite a while, just chasing down all of the bubbles.
And Ron, just for everyone here, are these going to be attached to the agenda when the webinar goes? Is the
Yes, we'll send out. Yeah.
Wonderful. Thank you.
Slides 2 from today. Yeah.
We could probably develop this into a game, law school game.
Agreed. It's a million seller for you, Ron.
So based on all of the profiles that I presented earlier and the different ratings, one of the ways trying to address those profile or practice settings to control for potentially their confounding effect, whether it's the size of the firm or practice area, in an overall comprehensive framework controlling for all of those, what this chart shows is at the end, what's really important, showing up as very clear different patterns. On criticality, the higher ratings tend to associated with later stages of the case matter process. We saw that earlier in that color-coded table. And it's also associated with attorneys practicing in DA and PD when they selected their settings. And this is a fairly large difference, accounting for about 0.5 in the overall rating. Higher rating also is coming from attorneys practicing in criminal law, immigration, and dependency. Out of all of those different practice areas, these three jumped out as having a higher rating on criticality, and lower ratings by in-house attorneys. And no difference by firm size as far as criticality is concerned. But when we look at, in the same way, at ratings on depth of knowledge, higher ratings also share similar kind of characteristics. It's associated with the later stages of a case or matter, higher ratings by DA and PD. Here, firm size makes a difference. For those with more than 10 attorneys in the firm size, the rating on the complexity or the depth of knowledge required to perform their task is higher. Higher ratings by attorneys practicing environmental law, IP, professional malpractice, and taxation. A lot of these, when we presented the results to focus group attorneys, whether it's the first few years or experience, they, based on their actual experience, validated the findings here, controlling for a lot of those confounding factors. Here's a chart just showing, eliminating all of those confounding factors. At the end, what is the difference across experience level in terms of the rating on potential harm or criticality? The first 3 years, looking at within that confidence interval, there doesn't seem to be a lot of difference. But you see a clear upward trend by the 4th and 5th year and continue to rise significantly within that scale. Similarly, for knowledge, depth of knowledge, the first 3 years, it's uneven, although all within that very wide confidence interval. And by the 4th year, it begins to rise in a similar fashion. This is also confirmed by focus group in their actual experience. Partly, it represents the structure of employment the first 2 to 3 years that they are in a position of associate attorney, and also the responsibility because they have to report to their supervising attorney at the end. It's the supervising attorney who is more responsible for their sense of the criticality. As a result, is lowered for the first couple years. A lot of those results, as I mentioned, is similar between the two survey methodology, but there are some areas with some consistent differences which I attributed to this difference in the frame of reference when they respond to the survey, but others might require a little more analysis. Here are examples of the difference in their ratings of a criticality. Ranked the highest is factual and legal analysis on both survey scales. Resolution the second highest, followed by practice management. You can see the difference between the two survey results. The average for the traditional is higher consistently compared to the ratings from ESM.
Ron, this is Greg Brandis. Can I ask a question? Just to inform as I'm looking at these. The 3 and the 4, how exactly were they defined in the survey, in the words of the survey? The descriptor applied to 3 and the descriptor applied to 4.
Like potential harm, 1 would represent no harm at all.
Yep.
When we move to 2, it's moderate and substantial. I remember 5 is extreme.
So 3 is substantial?
3 is substantial,
okay.
Yeah.
And 4 is?
I don't recall 4. we'll give you the descriptors. We'll look it up and let you know.
Okay.
But both surveys use the same rating scales and descriptions, but consistently, ESM surveys rated them lower. Part of this is this recall kind of a framework often involves social desirability. You wanted to rate something based on your value judgment rather than immediate reaction to the things that you have at hand. So 3 is moderate. 3 is moderate. Yeah.
Can you just run this? Can you just run the scale for us?
1 is no harm at all. 2, minimum harm. 3 is moderate. 4 is substantial. 5 is extreme.
Thank you.
As I mentioned earlier, the 4 areas of responsibility consist of 13 what we call competency areas. The next chart is a similar comparison between the 2 survey results on these more detailed 13 areas. And here it's ranked in that descending order from the ESM survey results. Litigation ranked the highest, negotiation and closing. These are the end part of the process of handling cases. And you can also see some of the differences are fairly small between the 2 survey results and others are fairly large. For example, maintaining client relationship, the average rating from traditional survey is 4, and the ESM is 3, 1 full point, which is very significant in the overall distribution.
Ron, this is Marty Pritikin. I have another question. When you showed the traditional survey results and you showed that 8.3% of participants actually completed the survey, how does that compare to what the expectations were? Was there concerns that that was a substantial enough group to be representative? If you can comment on that.
First of all, about 8%. Based on many prior bar surveys, typically we get response rate from 7 to 10%, like the 5-year survey that we sent out 2 years ago. But that has to do with the length of the survey. This traditional survey, I think it's more than 50 pages that you have to go through, and each page you have to click all of those 3 ratings. Overall amount of time estimated is 45 minutes to an hour. So from the beginning, we're very concerned about the challenge of getting people engaged and completing everything. So 8% I would say is great in terms of as a response rate. Representativeness, we had information to compare with the results from other sources of survey, and both the ESM and the traditional survey in terms of distribution of the characteristics are very comparable. In terms of reliability sample size, traditional survey, 8% represents about 5,000 responses. So 5,000 as a sample size, usually you can produce quite reliable statistics to look at, depending on the level of the breakdown of all of the variables. So overall, whatever measure you use, I think we're very pleased with the response rate, the total number of responses.
Great, thank you.
So taking all of these data, the purpose of the focus group is to get more insights from their experience. We just yesterday we finished the focus group with the experienced attorneys who had experience supervising entry-level attorneys, and the day prior we had 12 young attorneys ranging from the first year to 3 years of experience, just to get their feedback about what they think of the results. A lot of validation from their experience, as I mentioned earlier. At the end of the focus group, after going through a lot of discussions and the implications of the survey results, their experience, the bar exam, based on all of those information we distributed a short questionnaire to ask them if they had the discretion to determine the proportion of the bar exam content coverage based on all of those legal topics presented on the survey, what their distribution will be. It pretty accurately reflects the survey results, although I would interpret it as somewhat different because they understood the different results from traditional and ESM, and then adding some additional consideration. What I'm going to share is the fresh results from yesterday and the day before's focus group. On content, this is adding to 100%. They just rated all of them on the basis of percentage distribution. Civil procedure came up on top for both experienced and newly licensed attorneys. You can see about 70–80% is accounted for by the first 6 or 7, similar to the actual distribution from the survey that I discussed earlier. And this is also from their experience. The legal topics that they mentioned had a lot of a crossover or heuristic value. Regardless of the practice setting, these tend to be the legal topics of knowledge that they rely on. That's their justification for assigning the percentage. Next is steps.
Ron, can I ask a question?
Sure.
On this top list over here, we had constitutional law, but constitutional law wasn't one of the top 6.
Right, it wasn't. Neither was professional responsibility. Right. That's why this is different than direct response to survey in their rating. This is after discussion and then reflecting a little more about the other values and other considerations, the result of their decision, taking the average. And it's pretty consistent between the two groups, young and experienced attorneys. So there are different reasons for rating something higher than the others. The follow-up steps is, in addition to just going through more of the data, as you saw, there are tons of data that we can try to answer different set of questions. In our next 2 conference calls scheduled with the working group member, that's for purpose to help the working group members have a better understanding of a lot of handouts that we distributed, the tables that we produced from the earlier part of the analysis. And then going back to a couple full-day meetings, trying to see, given what we saw the data represents, what it means for the bar exam, and then to what extent we can use the information to come to some definition of minimum competence, to define the construct of what the bar exam is supposed to measure. All of those based on what so far represents very solid information from the 2 survey results. And a final report will provide an evaluation of the data as well as answering some of those questions about the bar exam design issues.
Thank
Any
you.
questions?
Yeah, thank you, Ron. So I thought how we could set it up is to start with member questions or discussion, then go to public comment, come back to member so that we can play off each other, and then as time allows, go back to public to make sure that everyone has an opportunity to ask questions of Ron and to spark any discussion that may come up as a result. So I invite any members who may have or discussion points.
Process question, Ron. You said this was the preliminary analysis of the data. What other analyses are you thinking you're likely to conduct, just in general terms?
Preliminary nature, different in the traditional survey and the ESM, partly just the results of this pace of getting to the bottom of the data. ESM survey, what remains to be done is to look at the results, accounting for other factors in different ways to make sure. For example, one of the things that we try to capture about the legal topics is we know the respondents can select up to 3. One of the ways of asking about the frequency distribution is to see to what extent their selection of related legal topics tend to cluster together. as a way of representing sort of a network of legal topics. That's not critical, but useful information to understand. That's also a unique feature of the ESM survey results. Traditional survey, the structure of the data is more unwieldy. So they have to do a little more breakdown of the different levels. So that's additional information currently is not displayed in a way that's easily absorbable in the tables that we have produced.
Can we also have the descriptors for the depth of knowledge rating? So earlier we had the descriptors for the harm.
One
rating.
is recall.
One is recall, yep.
2 is understand.
Mhm.
3 is apply.
Mhm.
4 is analyze. 5 is evaluate and synthesize.
Thank you. Okay.
Other questions?
Yeah, I know you touched upon the fact that this is going to be moving forward with other groups to kind of decide policy questions, but I'm curious about how all of the previous studies, this study and the NCVE study, would be used in order to kind of design what we're going to do with the bar going forward, and which body will actually do that analysis and make recommendations.
Recommendations from the data is part of the expected results in the final reports, and the current working group for CAPA study will be part of that process. And the specific recommendations will cover different areas of our exam. The first part is directly related to what motivated the study, which is the previous content alignment study found the job analysis results were not current, so we need to have updated information about practice. And following the sequence of all of the testing design, the first thing is what's the coverage in terms of breadth and depth. So that will be the first part that we will have some recommendation, I think. And the second part is the definition of minimum competence as some construct as the basis to take to another step for the bar exam. We also have information about the relative importance and all of the other ratings in both dimensions in terms of performance or task relative to knowledge. And this is the issue. Roughly, you can make the distinction between knowledge and skills, or a lot of times attributing to the focus of the multiple choice MBE versus written, or essay versus performance test. All of those, we have information from the survey results that we can begin to address in a more rigorous, empirically based manner. So that will be another set of considerations and recommendations. That certainly bring up another set of a question. Knowing what you need to cover, knowing what's the relevant importance of different domains, whether it's performance, practical areas, or versus knowledge, what's the best way of measuring those things? So the format of the bar exam will be the last, I think, in following that sequence.
Other questions or comments from members of the council or CS bars? Yeah, Jay?
Just one. Was there any type of disaggregation done to the knowledge domains between California law versus federal?
California law. We didn't specify, for example, civil procedure. What they actually are using is California versus or federal civil procedure, although that came up from the focus group. So the data, we don't have this aggregation at that level because that was not part of the question in the survey. The issue came up in the focus group.
And just as point of reference, I am a member of the California Attorney Practice Analysis Working Group, so I have been able to be a part of the meetings that led up to the survey, and then I had the opportunity to be exposed to these numbers, thank God, once before. And then we're going to have updated meetings to help us work through them even more. for those less confident with statistical analysis, and I put myself in that camp. First of all, I have to say, while I think we can always find things that may not be in the best with any statistical analysis, with any survey, that I have been incredibly impressed with both the State Bar staff as it relates to this survey, as well as the independent consultants that they brought in to work with us. They were incredibly responsive to the working group's feedback, as well as bringing in the panel at the time that the survey was being created, and now the focus groups of both new attorneys and experienced attorneys who supervise new attorneys to really flesh out the data. And so it was exciting for me to see this, to see the data come out, both as a legal educator, because I think all of us who are in legal education want not just for our students to pass the bar, but we want them to be skilled, competent, and ethical attorneys. And knowing and understanding what those new attorneys need as they exit law school and begin the practice of law, I think will just help us hone our curriculum and really teach and use data to help our students understand what's important when they first exit law school. And it was also striking to me that apparently across the board, that idea of criticality is not something that we are emphasizing enough in law school, or perhaps it just takes experience to truly understand the harm that a lawyer can wreak on individuals or a system. So I just want to say thank you to the State Bar staff for this process. And Ron, if I'm not mistaken, while the NCBE has done a job analysis study, California is going to be the first state to have completed one. I know some other states are in the process now. Is that correct?
Yeah, 2 additional states just started.
So despite having 50 states with bar exams, not one state has done a job analysis study to ensure that the content of that bar exam through the years have reflected what a new attorney needs to know and understand. And as part of the CAPA working group, that the data, the question is being raised is now, what should the bar exam look like, both in content and in format. So I invite not just questions about the data, but really to start the conversation with those of us here on what we glean from this information about what kind of things we think would be helpful. And some of the things that came up in the working group is, even before the survey data, is fewer topics and a focused concentration on some of those performance, the research and writing, the drafting, the factual analysis and legal analysis being a focus, with fewer topics being a target. So I'll invite, Brian, do you want to comment before I move to public comment?
Yes, I'm sorry, I forgot to ask. Ron, this is Brian Pertil. I'm just curious, since litigation, civil procedure seems to show up at the top of these lists on criticality and depth of knowledge, and maybe you have this and I missed it, is there a number about what percentage of the responding lawyers were actually litigation attorneys?
Based on practice type, civil litigation, as I showed, is the highest category selected.
Of the responding lawyers?
Yes.
Okay.
Although I don't know when they select civil litigation, to what extent that represents actually a litigator or some other kind of a.
Okay. Yeah. All right. Thank you.
You're welcome.
Thank you. Invite public comment. I think you need to put on the microphone for the webinar. Thanks, Mitch.
Ron, impressive data. Thank you for that. Let me ask you, for those of us who are thinking about the future of the bar exam, how would you rate your confidence in this study? Not as to form of the bar exam, but if we were to say, does this study give us confidence to pick, based on criticality and depth of knowledge, the top 6 topics
and frequency
yeah. The top 6 topics and the top 6 skills for a future bar exam as a starting point for that conversation?
If 6 is the magic number,
Just to pick a number of 6, yeah.
I think numerically the results is very clear. The harder question is whether it's 6 or 10,
okay.
Right? Whether it's in terms of just one of the 3 measures, frequency, whether it's ESM survey where you have the percentage distribution and the traditional 1 to 5, the average, where do you draw the line to say this is what from the survey results actually represents important and frequently needed areas. So that's another kind of a judgment. We, from the focus group, we already saw results and considerations taking into account different factors. So survey is the base, I would say, just the very basis to begin that kind of a discussion. So how confident, as long as the process is to use empirical data to add additional considerations, whether it's policy considerations, bar exam, or law school curriculum, all of the alignment across the board, those additional factors will be the second step using the empirical data. So to the extent that's the process, I'm confident about the results of the data to be useful as the foundation.
All right, very helpful. Thank you.
Ira?
Hi, I'm Ira Spiro. I'm the Dean of People's College of Law. There's a concern I have for the benefit of the state bar and California attorneys, members of the bar, which is this. It's a rhetorical point. For instance, the term, and this is the main one, the term degree of harm. Could it be changed to degree of potential harm? And I say this, I don't mean to be flippant, maybe this is a little flippant, but I think it's possible. Say the press saw some of these screens that said degree of harm, and I can imagine some headline someday saying California attorneys rate their degree of harm as moderate to severe, or something like that. And there may be other terms in this study that, without changing the meaning of anything or changing how it reflects the survey responses, study responses, there may be ways to change the terms that would reduce the possibility of them being embarrassing to lawyers of the state bar.
Whether the term is degree of harm or criticality, I think when it becomes a headline, it's taking the information entirely out of context.
It is, but that's that's what the press often does, and sometimes understandably, because they don't have time to get into it. Sometimes not understandably,
And in the focus group, they provide more nuanced context about what went into their assessment of these ratings. For example, first-year attorneys, they acknowledge a lot of times they don't have the full information about the entire process of the case to accurately assess not only immediate but also potential harms. So experience, partly it's an experience of seeing the entirety of the case and all of the stakeholders and clients to have that accurate assessment, although to a considerable extent their assessment is also based on the nature of the task as well as their responsibility. So it's a complexity of all of these dimensions going into that number if someone take it out of context.
Well, yeah, I agree. Well,
I just wanted to. This is Jennifer Manukin. I've just joined the call. I'm sorry to be so late.
Thank you, Jennifer.
In the last sentence or two that you mentioned, that you said, you did use the term potential harm, Ron, and I think that would be a big improvement over saying degree of harm on the title of something.
Thank you, Ira.
Thanks.
George?
Thank you. Good morning. I'm George Leal, Dean of the Irvine University College of Law. Ron, if you could go back, I'm just curious as a former litigator, the chart you had regarding criticality, the the difference between the traditional?
Oh, the comparison chart?
Yes.
This one?
No, the other one.
The detail.
Yeah, that. I'm just curious, I think everybody who's litigated a case would agree that virtually everything under litigation falls within litigation. They're starting with communication, practice management, drafting and writing. So my question is, what was referred to in quote litigation?
Now this is based on the classification of the responsibility areas and further broken out into 13. The way they look at the entire inventory of the day-to-day tasks is starting from the very beginning of receiving a case. So you begin to deal with issues related to establishing client relationship, maintaining relationship, moving further into the process, like issue spotting. At the very end, litigation is taking the case to the court, almost like trial process.
So it's more trial practice?
Yes.
Okay. Thanks.
There are additional details under each of the 13 areas.
Other public comment before we move back to the committee? Any follow-up comments from the committee? And Jennifer, I'm sorry that you missed it. We just went through the California Attorney Practice Analysis Working Group results from the surveys, and Ron took us through it. And Ron, I believe the PowerPoint that you presented will be available as part of the agenda once the webinar goes live. So everyone will have the opportunity to go through it with more care and play with your very cool slider thing that you created.
That should be L1 first class.
Yeah, absolutely. So Jennifer, you'll have a chance to go through it, but right now we're just having public comment on what people were able to see, and now back to the committee. So any other comments from the committee?
This is Greg. So I wonder if in the process that's ahead, there is any benchmarking step planned that is as against the present bar exam or as against other professional licensing exams, the degrees of knowledge and criticality that those exams set as expectations for minimum competence. In other words, if presumably the doctors and the dentists all have the same challenge of evaluating not only knowledge domains and the depth of knowledge, but also ranking those domains. And presumably there is some measurement number or some tool that they use to decide. And I was wondering if there was any planned step, again, not to add to your burdens before a December deadline, but benchmarking this data as against that data to gut check it, frankly, against similar settings.
I think that's the purpose of the follow-up conference call that we scheduled. The first conference call is walk through all of the detailed data. The second part is to help working group members understand and interpret the data so that coming back in November for the working group meeting, we can sort of have a sense of operationalize the data in order to make that next step to discuss what the data means in designing bar exam, various aspects of the different issues. The first thing for most direct link, you can say, frequency distribution, give you information about the coverage, setting aside the depth of the knowledge issue. Then certainly, similar to the focus group response, they know that there's this frequency distribution of professional responsibility is low, but then there are other considerations so that in their assessment they actually rated it higher in terms of the coverage, the need to cover them. I'd imagine it will be a similar process, a lot of empirical data, consideration of different policy issues, and finally it's a judgment. Considered judgment based on data.
Okay.
Ron, I'm thinking back to my early days, and I don't see working nights, working weekends, ignoring family anywhere on this list. So I'm wondering, what does practice management actually include? Does that include life-work balance, or just how you run the law practice? or something else?
I can give you the list. You want to read it out?
Yeah, so under the 13 different task areas, we have further sub areas. So under practice management, we have determining necessary staffing, managing staff members, complying with state bar licensing and reporting requirements, creating the practice's budget, managing the practice's finances, managing client trust accounts, managing appropriate insurance coverage, managing IT requirements and resources, managing service vendors, marketing the practice in compliance with requirements relating to attorney advertising, managing files and records, and lastly, maintaining calendar.
I think, Brian, this is Greg Brandis. I think, Brian, your question goes deeper to the characteristics that make young lawyers successful. There's been a lot of work that's been done on that. ILS, the Educating Tomorrow's Lawyers group, and the foundations for practice that were described there. And I think those things were not included here in the main at all. And obviously that's a consideration. That I would suggest that the CAPA group be sure that it keeps those things in mind on top of all the things that we've talked about here. Because if you survey folks who are in a position to supervise young lawyers, most of them will tell you that those things, in terms of their actual success, more important than any of these things. Although communication and some of the matters that are part of this survey are woven into some of those characteristics because they address behaviors and other things are sort of attitudes that are indicated by behaviors. But I would, I guess my first suggestion for the CAPA group is don't ignore any of those matters as you think about drawing a conclusion about the bar exam should include, because it's not just this. There's a great deal more that goes into being competent, successful, not dangerous, and the rest for the first year practice.
The ESM data actually has more to contribute to address your question. The 117 individual tasks, when it's laid out, the respondent has the option of, after selecting one of the 13 competency areas, they can select other, something that's not listed. And based on the percentage of one of the 13 areas, percentage that selected the other, it varies wildly. For example, issue spotting, research and investigation, those specific areas' performance, less than 3% selected the other, which means that for these more routine kind of a legal analysis kind of task, our list is fairly comprehensive. We cover pretty much everything. But for case management, practice management, about 40% selected the other. We haven't gone into the text to see what they told us about the others are, but those are the additional information we, just on the surface, we know the distribution of the other as representing the comprehensiveness of the list is very different.
Susan Prager. Ron, I may have missed this in your presentation, but how is the timing of the California analysis going to track or not track with what the MBE people are doing?
From the beginning, when we were planning for the study, we understood the timeline for NCB is 3 years. The scope is there. All of the steps laid out is longer, and they specifically included within the scope issues like what's the timing of administering the different portions of the exam. But as far as survey distribution and results, we just happen to have all of it done within the past couple months. I haven't been communicating with them about sharing the results, but from early we had the agreement that we will continue to collaborate to the extent possible in sharing. For example, when they first created a draft of their survey, we looked across to compare with our list, and we have some ideas about the different methodology used and potentially to what extent we can compare compare the results. So those are additional follow-up work that I think we'll be able to follow.
One of the things that came to my mind as you were talking is that we've had this recent change in the move to the two-day test, where we continued to use the number of hours in the test to govern the weighting, and that worked a significant change in the weighting of the California components as compared to the multi-state. So I'm thinking as I listen to this that, because by definition it sounds like California's changes may come well in advance of the NCBE, that the bar may really want to reconsider that decision, and along with it consider whether it may be more important to use more of the essay time in the performance test format rather than the truncated version that we're now seeing with respect to that.
And for those of you who haven't looked, the NCBE is going through a 3-phase process right now, and they completed the first phase, which was the listening tour. The second phase is, and the listening tour report is available online. The second phase is the job study analysis, and the third phase is examining the content of the test, both the MBE and the UBE that they administer. So I think that's why it's a longer process in terms of it's embedded within a broader task force piece. Donna?
So just 2 comments on that, Dean Prager. Donna Hershkowitz, Chief of Programs at the State Bar. One is that as part of the State Bar's strategic plan, we are going to be doing an analysis that we expect to present to the Board of Trustees in January, this coming January, looking at the impact of the 2-day exam. Additionally, so that should have some information for you on the transition to the 2-day exam and the different weighting, going from doing the 50-50 weighting between the MBE and the written portion. And so I think that will provide some valuable information on that. But regardless of what that shows, any content validation study, which, as Ron mentioned, is really the natural outgrowth from this attorney practice analysis. Any content validation study includes not just what should the topics be, but it includes how they should be weighted and how they should be scored. And so that would be part of that kind of analysis as well. If the focus is on, if it is clear, if it becomes clear, just making this up, that the most important thing is writing. That is the most important thing that we get out of this practice analysis. The most important thing is somebody's ability to write. That factor might go into, well, should the memorization of substantive knowledge that I can give back to you on the MBE be weighted equally with that critically important writing? That would absolutely be part of the analysis.
Thank you.
Anthony.
Yeah, Anthony Nedwicki, I just wanted to follow up on some of those questions. Is it possible that we would just not do the MBE? I mean, there's obviously, when you're looking at these results, the topic areas on the MBE and the topics that you've shown, there's clear overlap. But I mean, is there the possibility that we would just have our own test that wouldn't be part of the National Conference of Bar Examiners?
Not being a psychometrician, but I can say, as design consideration of a testing instrument, MBE, regardless of all of the flaws related to memorization or other things, which I don't know to what extent is the case, the strength lies in the number of items in the test and the objective scoring. So the properties of any testing, you have to have reliability, fairness, all of those essential elements of a testing. And the only way to ensure considerable reliability is to have one component that with multiple choice objective grading and sufficient number of items. Because with testing, you have to be able to use that reliability to have another characteristic of testing is the discriminating in terms of a difficulty level. Without that kind of reliability, it would be very hard to use any test to achieve that goal.
But is the MBE the right one? I mean, because if your study comes out and there's 4 topics that are critical in California or through your study, but not through the MBE or tested on the MBE, does that mean that you would do your own multiple choice exam?
So it's an issue of format versus and content coverage.
Yeah, I would just say that nothing is off the table, right? We want to see the results, figure out if the content of the current content and structure and format of the bar exam is consistent with the results that we have in this attorney practice analysis. And if it's not, then what should the format and scope be? I really think nothing is off the table. Everything is open for a true and honest discussion.
So I want to thank Ron and Eli for coming to do the presentation. It's just to keep us on schedule. We're going to break from 12 to 12:15 to get the box lunches, come back here. When we return, we're going to have another opportunity to learn about the Justice Gap Survey and the Law Student Survey and how the two connect. So if we could take a break from 12 to 12:15 for the box lunches, come back here to have a working lunch from there. So we're just going to see if the webcast is set. Okay, thank you. starting the webinar again. So I love how I command a room. So we're gonna be starting up the webinar again soon, and we're gonna start with we have reconvened the meeting, the joint meeting of the Law School Council and CS Bars, and we are now going to continue our meeting with a presentation by Helen Hong and Eli Wallach on the Law Student Survey and the California Justice Gap.
So I'm Helen Hong. I am the Director of the Office of Access and Inclusion. And before we dive into the Law Student Survey, which many of your students participated in, and you gave us input earlier this year at the Law School Assembly, I wanted to just give a little bit more context as to how this fits into the Justice Gap study. What the State Bar wants to understand is how to better support low and moderate income Californians, and obviously to understand how to prioritize limited resources, and to understand how the cost of legal education may impact access to justice. Specifically querying whether or not a loan forgiveness programs influence career choices. So with that, the Justice Gap study, which will be completed by the end of this year, has 4 major parts. The first is a survey of nearly 4,000 adult Californians to understand how they interact and deal with possible legal issues in their lives. It incorporates information from the intake census of nearly 70 legal aid organizations in California funded by the State Bar. So basically, who's seeking legal services, what kind of services are they receiving, and are they being resolved? The second portion is the law student survey that Eli will talk in much more depth about today, which seeks to understand how law school debt impacts career choice and specifically access to justice. We've also partnered with the Legal Aid Association of California to conduct focus groups, and I know that they've occurred at some of your campuses. We've asked that they reflect not only ABA, but CALS and registered in rural areas as well as urban areas. This will also incorporate recruitment and retention report by the Legal Aid Association of California to understand how the pipeline and retention of legal aid attorneys are being fared during this economic times in California. And lastly, looking at literature review and analysis of the cost of law schools in California. So with that, the law student survey was really asking the question if we reduce law school debt, if salaries were increased, are there other factors in which more attorneys, more law students and attorneys would pursue careers in legal aid because the demand is so high, but we've also heard from our legal aid executive directors as well as other people in the field that there are fewer applicants for attorney positions, and once they're in legal aid, there's a high turnover rate. And so not only is there a gap in funding possibly, but there's actually a gap in the workforce. And so we want to really delve into what impacts career choice for law students in California.
Hello, everybody. My name is Eli Wallach. I'm a program analyst in the Office of Research and Institutional Accountability, and I also administered the Law Student Survey portion of the Justice Gap study, which I'm about to present to you all. Here's a survey timeline. As you can see, in July 2019, this past summer, we had a smaller launch to a smaller group of law students through LAC, through the Legal Aid Association of California, which went out to about 150 students, specifically interning at their partner organizations, which are largely legal aid organizations. That survey informed us as to the quality of the questions, and we used it as a prototype to help develop a larger survey that we sent out in September this year, that went out to all the law students registered with the State Bar of California, as well as through distribution through deans, through law school deans to their students as well. The survey closed in early October, and now we are working on reporting the results for a final report that will be released in December 2019. Yeah, thank you. And so all in all, we had about 2,500 responses, 2,476 responses to the survey. The survey distribution that went out directly to students went out to about 7,000 students. Of those 7,000 students, 2,000 of those responded to the direct distribution, and about 460 responded through the distribution through deans. This slide shows the breakdown of the survey respondents. As you can see, there's a pretty even distribution among law school year, and we do have representation from CALS and registered law schools, but the majority of respondents were coming from ABA law schools. And you could see the breakdown between full-time and part-time based on law school type. Just for notice, in the rest of the analysis, because I have a few out-of-state law schools, and out-of-state law schools are we're all ABA accredited, I folded those into the ABA category for further analysis. These slides are going through the demographic questions that we gathered. The demographic questions are for the purpose of isolating out their effects, or controlling for their effects when we run an analysis on the effects of debt and career choice, as well as to make sure that our survey population is representative of the population of law students gathered from other existing surveys. Yeah.
I think this information is also in line with the office priority for diversity and inclusion and retention, particularly in law schools. And so this is a little bit of a preview of how the data is useful for the CS Bar session this afternoon, in terms of how debt may differ based on race and ethnicity and other diversity factors. And so we will be going through quite a few slides. We are just highlighting things that are really out of the median area. So like what you will see here on this slide is that the ABA schools have the largest LGBTQIA population, much higher than the mean. And we'll be just highlighting. We're not going to go through all of it. There's a lot of data, and we're very excited to present that in the entire executive report of the Justice Gap Study, but I wanted to put that in context.
Thank you. Thank you very much. And so, yeah, here we're going to share these slides so you can see the breakdown on race, ethnicity, gender, sexual orientation, and also by law school type. In the next, we also asked about whether or not they anticipate having to support others besides themselves when they graduate law school, as sort of a measure to indicate age and whether or not they will have a family after law school, because that can influence career patterns as well. Same, we use parents' education level as an indicator of socioeconomic status, as in line with a national law school student survey. And then we have veteran status and identifying with a disability.
So I think 3 areas to note is the majority of law students, when they are graduating, are likely to support others. And surprisingly, well, not surprisingly, but the vast majority of ABA students have one or more parents that do not have a college degree, which is actually higher than the CALS and the registered schools.
Sorry.
Oh, that was the opposite?
Yeah, that was the opposite.
Okay.
So, yeah. You could see that actually it's CALS and registered have higher proportions of people in which neither of their parents hold a bachelor's degree. Yeah. And Helen is right about just a really large proportion of people, particularly in CALS and registered law schools, they anticipate having dependents when they graduate from law school. And so a major focus of this survey and of the analysis that we're doing for the Justice Gap has to do with law school debt. And so we asked participants to indicate which types of law school debt that they had. The top chart right here shows what percentage of students in the different types of law school had each particular type of debt. So you can see in registered, excuse the subline right here. It should be like ABA CALS registered. So registered has the largest proportion of students without debt, and federal law school debt, ABA, have above the average, and as what we would anticipate. And when you look at median law school debt, you can see here that ABA has a much higher median law school debt, which is in line with the cost of law schools as well. Note that all these figures here with median law school debt are in increments of 1,000. And as you'll see as we look at debt, we have we breaking it down by median law school debt and median total debt. Total debt includes these two categories here: other educational debt besides law school debt. In this analysis, when it says no zeros, that means that we took out people that did not have law school debt or did not have educational debt from the analysis. So if we look at the total here, we'll say median 50% of law students have less than $89,000 in law school debt. However, if you look at all the students that have law school debt, you don't include the students that do not have law school debt. You can see that of all the students who have law school debt, 50% have more, 50% have less than $120,000. So when you look at debt characteristics, just because we didn't want to bombard everybody with a bunch of bar charts, I took out some interesting trends or findings from looking at the different demographics and debt. And from it, you can see that women and people who identify as non-binary reported higher median debt levels than male students. That's law school debt. Let me pull it up. And that's law school debt. And then Black and Latinx students reported higher median education to total educational debt levels, over $20,000 higher when it comes to total educational debt. When you're looking at the medians compared to the total population, you see other disparities in LGBTQIA plus students reporting higher median levels of debt than the total population. Disabled students report slightly lower median law school debt than the population median, but these differences disappear when students with no debt are excluded from the analysis. Part of this can have to do with scholarships. Is when I look at the differences between the analysis with the students with no debt and without, it generally indicates where more scholarship funding is going. And veteran students do report substantially lower levels of debt than the population median. And so how are we using this data? What are we calculating and what's going on here? The focus of the study is really looking at this term public interest drift, which you might have read about in the literature. And it refers to this phenomenon in which at the beginning of law school, you have a large percentage of people who are students who are interested in public interest, and by the end of law school, it's been cited, it shrinks. And our data it also reinforces that or supports that finding as well. In the study, UC Davis when they looked at 1Ls versus 3Ls, the drift rate they calculated was around 33%, and that is similar to what our adjusted drift rate is. And so, to take a step back, our drift rate here is looking at, okay, how many of the students who started out interested in public interest, how many decided to change? So when you look at the Y variables here, those are what people started out as interested in, and the x-axis, the horizontal axis, is what they're interested in now. So that's looking at all the red. It's saying of all the 510 students who started out interested in public interest, how many were still interested in public interest at the end, or how many drifted? So those red boxes, you sum up the red boxes divided by the total who were interested in public interest at the start of law school, and you'll get a drift rate of about 45%. But now that drift rate is very high, and it's high compared to other studies as well. But that's because this is following students across. Other studies have looked at snapshots at 1Ls versus 3Ls. When you do that here, when you take into account that people also have moved into public interest, when you look at that vertical blue, those blue boxes, you can adjust the drift rate to take into account the people who have moved in. And so when you look at the population of students who remain interested in public interest, then you get the adjusted drift rate, which is basically looking at the population, saying if we had 100 students who were interested in public interest jobs at the beginning of law school, how many can we expect to have at the end of law school? And that population will have decreased by 33%, according to these findings. And so we ask a series of questions about why drift occurs. And as you can see here, overwhelmingly students reported that the need to make more money than public interest jobs pay because of their educational debt was the most common cited reason why they drifted away from public interest. And when you look at the median debt levels in that bottom part of the slide, you can see just a pretty dramatic difference between the total student population and those students who do tend to drift. And those are the students who do have high levels of debt. And moreover, we ask the students to rate existing loan forgiveness or loan repayment programs. We got analysis. We ask about LRAP programs at their law school. We also ask about the Federal Public Service Loan Forgiveness Program, the PSLF. And they can comment on other. Not very many students commented on other, but they did provide a lot of ratings and a lot of comments about existing loan forgiveness programs. And as you can see, law school LRAP programs rate higher than the federal program, but it's still negative in terms of confidence that they will receive funds from the program and feeling more financially secure because of the program. And this is in the comments that we got about why to explain why, because when they rated low, we asked why, and they could write a comment. And a lot of them echoed that their salary has to be very low for them to receive funding. A lot of them echoed that they felt that they couldn't get married if they got it because their spouse income would be taken into consideration when they were to be receiving the funding. A lot of them complained that it was burdensome and complicated to get the money, and it was also inadequate considering costs of living in California.
And then just for context, when we're talking about civil legal services and legal aids in California, One just conducted a salary survey this year, which was published, and the median salary, and this is not even a starting attorney, but a median staff attorney position in California is paying an annual range of $65,000 a year, which has increased $7,000 over the last 10 years. And so when we talk about what the salaries are in context with loan repayment programs, it isn't necessarily livable in many of our metropolitan areas.
And then finally, we also asked about people interested in who are going to public interest jobs, where they would look to apply or look for jobs, as a way to sort of assess what is the existing pipeline to public interest jobs, and we'll report on that. And as you can see here, most people are looking at the organization's website or would know somebody, and career services is fourth, as well as public interest, public sector, career days. When asked specifically about legal aid, we got a lot of people saying that these public interest jobs should recruit more at CALs or at their law schools because they feel like they're not finding where the opportunities are. And we also asked for them to rate their law school's career resources regarding the career intended practice area that they selected. And as you can see, the private sector is rated the highest compared to public interest, which is a little bit below the average for the total. So right before we get into discussion, just sort of placing this data, this is a lot of, since we closed the survey recently, we're still working on a lot of the analysis, and I'm working on creating a model that's able to basically predict drift based on law school debt. So indicating how much, if we were to change a student's law school debt by 1%, what is the likelihood that they would change, and what would be the change in likelihood that they would drift away from public interest? This is going to help us create an estimate of what different sort of policy recommendations, or if we need a certain amount of lawyers to fill in the justice gap, how much debt would need to be reduced among students. And it's actually a very exciting model. There's not that much in the literature that goes into depth about the specifics of debt burden and how it influences career choice, let alone how much, if you were to change that debt burden, how career choices might shift. And so it has a lot of statistical exciting possibilities from it. But I just wanted to open it up to questions and also ask you all whether or not the survey reflected what you are seeing on the ground among law students. Also, if you have encountered effective strategies that facilitate the pipeline going to public interest and specifically legal aid careers, I ask that you share, or we're going to share the email after this if you want to share privately. And then also open up the conversation as to next steps in terms of the justice gap.
Thanks, Eli. And just before we get started, unfortunately, I'm sensitive to the time.
Yeah.
This meeting is slated to end at 1 with one more presentation happening. So
Okay.
I don't know if we're going to get to all the questions that you've posed, but hopefully we'll be able to start the conversation. And it looks like, Kareem, you'd like to offer a comment?
Yes. First off, thank you for the presentation. I think you captured a lot of data and tried to give it in bite sizes, so I really appreciated that. Part of my question is, you didn't ask for age or generation, so I'm wondering why that wasn't done. And my, in terms of the survey population.
So what we tried to do was, one, ask the same questions that we ask in my state bar profile, which is really based on the census, as well as categories that are identified as being categories of diversity under the government code, which does include age, but not necessarily generation.
Okay.
But again, in the framing of this, it was about the pipeline for civil legal services based on law school debt, so we didn't prioritize age. If that's something that you think is a major consideration, we didn't see that as a major factor, but Dawn, am I missing anything else on that?
Well, so we are going to be, we're talking about repeating the survey in the future, and so that's certainly something that we could add.
Yeah, I think the only reason why is because as I've visited different law schools, I've seen different age ranges, especially in our CALs. As an opportunity schools, I've seen different generations in the classroom. And so I think it's just what it does, I guess, from a representative such as myself, is it gives me more ideas of how the generations are perceiving justice and equity and diversity from their life perspectives. And to say that, I kind of have a different understanding because I'm a millennial, right? So I come from a different place, but I'm also from a disadvantaged community. So I always, when I see data or I see these reports, that's my lens that I operate with. So I would appreciate it if we could use that in the future. I really like that we found the demographics in the LGBTQIA, the Latinx, and the Black communities. I think those are areas that we are trying to get more information about, and part of the committee is trying to learn more about. So I think it was a great study. There's always room for improvement, and I would appreciate it moving forward if we could do that. So thank you.
Thanks, Kareem. Any other members have a comment or a question for Eli? Susan?
How much content do you have around the availability of public interest jobs, the jobs that are going unfilled?
We don't have specific quantified data. I can gather that I think was a good point.
I think that may be very important, and to see if there are some regional differences, because that's not my sense relating to greater LA, for example.
Actually, I know for a fact in LA, people are struggling in San Diego, rural areas. So my office also gives nearly $78 million in grant funding through IOLTA for legal aid organizations, and recruitment is one of the highest priorities in all regions. There has been an increase in funding, not only through homelessness prevention, but also with equal access funds, and many positions remain unfilled, even in LA. And so this is something that I'm hearing in regardless of geography, particularly much more difficult in the rural areas. But our focus group has actually found that rural areas are more likely and interested in access to justice with legal aid organizations in rural areas, which isn't surprising because they're in more localized communities. So I just wanted to respond to that.
Yeah, Anthony.
Yeah, Anthony Nowicki. I wanted to, the group that seemed to have the lowest amount of debt were veterans, and for obvious reasons because of funding. Did we see the same type of drift, or do we have the data to show if there was really a big drift among that population? Because that would go along with what I think is your underlying theory here.
I don't think we looked at whether or not what the population of interest, the public interest is of veterans in the first place, right? So that N would probably be much smaller, but we can also look at that as well as the testing.
Yeah, and just because the N of veterans is smaller, when I looked at a regression model of it, there doesn't seem to be a significant effect on veteran status and drift when you're controlling for everything else, when you're controlling for debt, controlling for everything else. But I would be curious about that as well, and I'll look into that. Thank you.
Greg?
Yeah, just very quick technical question. All of the debt number that we were looking at was all education-related debt. It was no other type of debt was asked about. Is that
correct?
Okay, thank you.
And I did want to open it up for public comment. Any questions or comments from the members of the public? Okay. I'm sorry we didn't have more time to spend on this, but I know there'll be other opportunities when the Justice Gap comes out and we start to talk about solutions based on the data that was discovered. Thank you very much for bringing this to us.
Just the last comment is that, as Donna mentioned, we will be conducting this survey to actually track the students. They all have their own unique ID numbers, so we don't have any personal information, but it's based on their emails. And so we'll be, based on your feedback at the Law School Assembly, we will now be proactively presenting, planning this for March 2020, so that we can actually see the drift from baseline from this year. And so I just want to put that on your radar so that you can communicate that to your students, but also to invest in this process. This is not a one and done.
Thank you. I believe now we've got a presentation on the Moral Character Working Group, an update on that.
Our next presentation will relate to the Moral Character Working Group that's been going on here at the State Bar, and you'll be hearing from David Lane, attorney in the Moral Character Determinations Department.
When you had to yell slide and then somebody would turn the carousel. But looks like we got this going. So yes, I'm David Lane, attorney at the State Bar in the Moral Character Group. And I'm just going to give a quick update. The Moral Character Working Group was put together with the goal of injecting more transparency, consistency into the moral character determination process. As it stands now, there are a couple of documents up on the State Bar's website. There's a moral character statement, which is a page or two that sort of describes the various issues and topics that we look at during the moral character determination process. And then there's a second document that has mitigating and aggravating factors that relate to those issues and topics. And so the goal of the working group is to consolidate those two documents and add to them and provide more clarity for applicants, for law schools, so people understand exactly how the process works. I guess I can just do this. There we go. And so these are the members of the working group. Several members of the Committee of Bar Examiners, including Jim Efting, the chair of the working group, are on the working group, and that's Jim and then Larry Kaplan, as well as Judge Torriabla. And essentially, we've had 2 meetings so far. We have several members of staff of the State Bar working with the working group, helping to facilitate the work they're doing. And that includes myself, the program manager of Moral Character Determinations, Tara Clark, and anyone else we need to pull in who can be helpful. We've had some great help from OGC. We had somebody from the Office of Chief Trial Counsel, Michael Glass, come in and discuss some of the issues that arise after applicants become attorneys in the discipline process. And so we've had 2 good meetings. Our 3rd meeting is next week. The goal is to have several more and hopefully come up with a final set of a sort of mission statement and guidelines sometime toward the end of the year or early next year. And this is a draft of the Moral Character Determinations mission statement. It may change, but this is something the working group has come up with thus far. And I'm going to go ahead and read it. The Office of Admissions advances the mission of the State Bar of California to protect the public, advance the ethical and competent practice of law, and support greater access and inclusion in the legal system by ensuring uniformity, consistency, and transparency in the moral character determination process. Towards this end, these guidelines were developed to communicate clear and appropriate standards by which moral character determinations are made and ensure that appropriate consideration is given to rehabilitative efforts undertaken by applicants. And I just want to highlight that last point before going on. I think this is going to be an important part of what the working group produces is a more clear description for applicants for law schools and others of exactly what the California Supreme Court has said applicants should do in order to rehabilitate themselves from prior acts of misconduct that may come up during the moral character determination process. And hopefully through outreach with law schools and perhaps other means, we'll get this information to applicants who can then prepare for the process and have time to undergo rehabilitative steps before the state bar looks at them during the process. We added there, please note that applicants have the burden of establishing the requisite moral character by demonstrating possession of traits critical to the ethical practice of law, such as candor and honesty, and respect for the law and the rights of others. So that sort of gives one an overview of the issues we're discussing and working with. And then this is a list, not exhaustive, but a list of various factors that are considered during the moral character determination process. The unauthorized practice of law, abuse of the legal process, violation of the law, discipline in other professions, perhaps, that have come up in the past for applicants, fraud, candor and honesty.
Has left the conference.
Candor and honesty, obviously a crucial component of the process. We look at honor code student conduct violations, whether in law school or undergrad. Prior license denials, either prior other jurisdictions, perhaps other bars, or other professions altogether, real estate licenses, things of that nature. We do look at past due debt and financial responsibility, which can include bankruptcy, although it's worth noting that bankruptcy alone, per se, does not reflect poorly on someone's moral character. But we'll look at, if somebody has abused the bankruptcy process, something of that nature, then it becomes relevant. Cooperation with the moral character process, again, criminal history. Drug and alcohol abuse. Drug and alcohol abuse, again, per se, is not what we're concerned with. What we're concerned with is conduct and the actions of applicants. And often drug and alcohol abuse are related to misconduct that's happened in applicants' past. Compliance with probation, lack of respect for others, rehabilitation I mentioned earlier, remorse, and then aggravating and mitigating factors. And so our plan is to produce guidelines that describe and provide transparency with respect to the sort of structured decision-making framework that we use when engaging in a moral character determination. We want people to understand how the process works and how to navigate it, and we want to provide total transparency with respect to the sorts of things that we consider. That's my last slide. And I'll mention the, I also wanted to do, I don't have a slide for this, but a brief update. There have been rules recently, state bar rules, recently approved by the California Supreme Court with respect to informal conferences. Informal conferences are essentially discussions that applicants are invited to attend and have in the past with members of the Committee of Bar Examiners, specifically the Subcommittee on Moral Character. These are applicants who serious concerns have been raised during the process, and this gives them an opportunity to come in, explain themselves, perhaps provide additional mitigating evidence, and discuss the issues with the decision makers. Under the new rules, it will no longer be members of the Subcommittee on Moral Character, but it will be staff of the State Bar who will be conducting the informal conferences. That staff will be myself. Under the rules, there'll always be an attorney in the room. It will be me unless I'm unavailable for some reason, in which case we'll pull in another attorney from admissions at the State Bar. Also, Tara Clark, the program manager of moral character at the State Bar, she'll be attending those, as well as one or both program supervisors. There are essentially two groups of moral character investigators at the State Bar. Program supervisors, there are a couple of them who supervise those two groups, and one or both of them will be present. And then in some circumstances, we will have more senior investigators attend the informal conferences. That's a fairly big change that the staff will be handling those. And the other big change under the new rules is the appeals process. So in the past, if an applicant received a negative moral character determination from the Committee of Bar Examiners, he or she could then appeal that determination to the State Bar Court, first to the hearing department, essentially the trial court, and then whoever gets an adverse or got an adverse determination or decision there could appeal that to the review department, essentially the appellate court at the State Bar. And then from there, whoever receives the adverse decision could appeal to the California Supreme Court. And then, of course, under very exceptional circumstances, if there are federal constitutional issues involved, theoretically, it could go up to the U.S. Supreme Court. Rarely, it's happened a couple times, but not in many decades. And so now the way it's going to work, since staff will be conducting the informal conferences and making the initial moral character determination, if an applicant receives a negative determination, he or she can appeal that to the full Committee of Bar Examiners. And if the applicant receives a negative determination there, that is, if the committee affirms, in effect, the decision of staff, then the applicant can move on to the State Bar Court, hearing department, review department, California Supreme Court. So in effect, the applicant will have an extra layer of appeal to go through and have more folks take a look and make that decision. And that is my brief overview of the Moral Character Working Group and the new rules concerning the informal conferences. And if anybody has any questions, I'd be happy to field them.
Thank you. And again, sensitive to time, and I know this is such an important topic and there isn't a lot of time, but does any member of the committee have a question or comment that they'd like to relay? Anthony.
Do you expect to have any guidance that will be sent to law schools when this process is done on being able to make our own determinations?
I'm not sure what...
The application process. You know, Deborah, the Stanford clinician, she did a great presentation at the law school meeting about how that funnel for people that have convictions in the past, it gets harder and harder for them to break into the legal profession. And one of those barriers are law schools. And one of the things I think we would want to correct is to make sure that we're not weeding out people that wouldn't be, would be able to go through your process. And so I wonder if there's just some guidance that would be able to be passed to the law schools.
Yes, the answer is yes. There's been discussion of various, outreach tools to the law schools. And you're absolutely right. One of the things that concerns us are not only applicants who don't make it because they don't get into or through the law school, but applicants who don't even try because they're disincentivized, because they believe because they have a felony, they're not going to become an attorney in California. And I should say there is nothing in California. There's no act of misconduct that prohibits somebody from becoming an attorney in theory, given the proper rehabilitation. So yeah, what that's going to look like is not clear yet, but we have had discussion about outreach to the law schools, ways that the law schools can inform law school applicants about the process, and then of course the students. It really behooves all of us to make the students aware of this process, and particularly the rehabilitation piece right at the beginning of law school, so that he or she, if need be, can engage in rehabilitative affirmative steps as they move through school. Sort of a vague answer I'm giving you, but your point is well taken, and it has been under discussion.
So I would add that, and Greg, this will come as music to your ears, that at next week's Moral Character Working Group, among the things that the working group will be discussing are some decision matrices where we are identifying, and we've just sort of done the very beginning of these because we want the assistance of the members of that working group to participate with us, but where we say that one of the qualities that we're looking for to have a positive moral character determination is that you possess the quality of candor or the quality of trustworthiness, respect for the law, things like that, right? Those are sort of the big qualities. And then we've got a decision matrix under that talks about, in this particular category, if you have, a bankruptcy, but there are no adverse actions and there are no, then basically that isn't going to weigh against you, and sort of going along the line of what poses sort of more question for a moral character determination. And the idea of this is, to walk through them with the law schools ultimately when these are adopted, but also, I think, equally, if not more importantly, have them posted on the website. The idea is, as David was suggesting, we want the law schools to understand these and be able to guide students and applicants to the law schools through these. And we want folks to see them themselves and have an understanding of, okay, there's nothing that says if you have X, you will never get a moral character, a positive determination. Here's where I think I am, right? And we all judge ourselves better than we are. But here's where I think I am, and I think maybe if I sort of do some of these things that are listed as mitigating factors, then that might help my chances of success. And so the goal of this process is transparency and consistency. And so we will put together as much documentation as we can for best practices for law schools and understanding for students.
So unfortunately, we're not going to be able to continue the discussion right now, but the Moral Character Working Group is meeting next week. Is that right, Donna? And you can sign up for alerts, participate or listen to it through the webinar if you're not able to come, but they are public meetings and everyone is welcome to come and provide public comment as part of that process as well. So thank you very much for coming to do the presentation. And at this point in time, we need a motion to adjourn the joint Law School Council CS-BARS meeting. So moved. So we will gavel out the joint LSC CS-BARS meeting. We'll take a 5-minute break and reconvene at 1:10 to allow kind of the transition to what will be just the CS-BARS meeting this afternoon. Again, thank you to everyone who came and participated.